Hello, everybody. Daniel is logging on. We just finished the 12 o'clock CLE, so we'll go ahead and get started because it's 1:03. So welcome to part two of the double header that Daniel likes to call double trouble. My name is Kamy Schiffman. I'm senior counsel with Thompson Co. And I would, along with Daniel, work in the professional liability section. What that means for me and who I've represented primarily are construction workers, real estate agents, real estate brokers, title companies, insurance agents, attorneys, engineers, really, and even truck drivers when they have an accident, because all of our clients in this practice area have been sued for something they did or didn't do, or allegations of that within the context of their job. Not all of them are technically professionals, but that's the terminology used. So we really handle a very wide variety of claims. It's not just strictly malpractice. So what I'm here to talk about today is the CLE is called Civility. It's a creed. And I'm going to start with, or go through a PowerPoint presentation to, um, Dan, did you know how I can share? It says it's not turned on.
Oh yeah, it wasn't turned on for me either. Well, let me figure out what I can do here.
Okay. So Amy and is it Zugi? I'm not sure how you say. I'm sorry.
Zuhei.
Uh,
Yes.
Zuhei.
Yeah, thank you.
Have either of you or either of you familiar with the Texas Lawyers Creed?
Yes.
Okay. I mean, it's okay. You know, if this isn't a test or anything, I'm not going to report to your supervisor or anything like that. So I will put this in the chat um, toward the end of the program today. But basically, this is a 8.5 by 14 page document that is the Texas Lawyers Creed. I'm going to talk. My presentation today is completely um, about the Texas Lawyers Creed, hoping that I can somehow get this displayed because I have a presentation to show to ask questions. I'm Y'all will just bear with me just 1 minute. Let's see.
I could not find the setting. I'm texting Lucy.
Okay. Um, just says it's sharing isn't host isn't allowing sharing. Are you hosting? Or do we know who the host is?
Okay, yep. So Brenda just texted me. Okay, it's sending Lucy a code, and we need Lucy to give the code to Brenda to activate the screen share or yeah,
Okay.
share screen.
So
It's being worked on, but sorry.
okay, well, that's okay. I'll go through some of the beginning questions. So, or beginning part of the program. So, do either of you know who in particular created and enacted the Texas Lawyers Creed?
No.
Okay. Do you know when it came about?
No.
Okay, so not trying to put you um, on the spot. In person this would have been like Family Feud style, but that's why I'm asking a little bit of questions. Um, okay, so I see HYLA is logged on, and they'll probably connect them. So the big surprise to me when I delved into this more closely, and I did that after, you know, I've read it before, of course. I've been a licensed since 2000, the year 2000. So I've been an attorney for quite a while, and I obviously have read, you know, and seen the Texas Lawyers Creed. But when I looked at it really closely after a program I attended in my Inn of Court last year, I was very surprised about when it was enacted. So there's an order from the Supreme Court of Texas and the Court of Criminal Appeals, and it says, in chambers this 7th day of November, 1989. So I had mentioned this to one of the person in my office who was helping with the PowerPoint, the IT person. And she said, "Oh, that's neat." And she says, "Would that come out in the 1800s?" And I said, "Well, no, actually, it's only like 30 something years ago," which is kind of shocking when you think about it, that it came about then. But it also explains that, and Brenda, we need sharing added if you're working on it. So it also explains that it is promulgated for a certain reason. In the order portion of it, what it states is, um, Brenda, are you working on the sharing?
Yes, let me do that now.
Okay. Um, we'll wait just a short while to see if she gets it going. Because I'd rather show you all the display, the slides.
Okay, it should be working.
Okay, I got it now. Let's see. Okay. All right. Oh, well, I ended up closing it. Somehow my Outlook was on. Hold on a second, guys. Okay. Can y'all see the screen? Yeah, I
Yeah.
can't hear anybody.
I-
Okay, good.
Yep.
Okay, very good. So there's our intro. And here's slide one, and points to either of you guys who are attending, if you know what this emblem is on the top right corner. If you don't know what it is from The Mandalorian TV show, because he explained in one of the episodes, somebody says, "Well, isn't Mandalore a race or people from a planet called Mandalorian? Aren't they from Mandalore?" And he says, "No." He says it's a creed, and that just stuck in my head. And so the Texas Lawyers Creed really is about civility, and the subtitle of it is a mandate for professionalism, as you see on this screen here. So to me, professionalism and civility really go hand in hand, and they are fundamental components of what our obligations are as attorneys. So we just went over this, who promulgated the Texas Lawyers Creed and what is its subtitle? I just answered that second part of that question myself. The subtitle is a mandate for professionalism. I will tell you guys, I've been doing this a long time, and in my practice area in particular, I deal with a lot of lawyers that don't seem to understand a mandate of professionalism or obligations set in the Texas Lawyers Creed. And I'll stop for just a moment and give tribute to the Garland Walker in a court, of which I'm a member. We did a program in April last year called Civility. That was the heading. I can't remember the exact title, but it was lessons about something like lessons about civility from modern TV. And we had skits from different that we wrote about different civility issues, including lawyers fighting and things like that. And for example, a fake case where Homer Simpson had sued Mr. Burns, for example. But I got this idea of doing an entire CLE on the Texas Lawyers Creed from them. So I'm borrowing that and want to give tribute to them. Okay. So number one, so here we go. The Supreme Court of Texas and Court of Criminal Appeals. And then the subtitle is a mandate for professionalism. You can see here a little image of where it says, hereby, the two courts hereby promulgate and adopt the Texas Lawyers Creed, a mandate for professionalism. And it has this 7th day of November, 1989. Okay, so the first sentence of the order identifies 3 characteristics for a lawyer's conduct. Anybody have a guess what they are or what one of them is? No. Well, I would guess it would say professionalism, civility, uh, and candor, something like that. What it actually says, let's go to the next slide, is the conduct of a lawyer should be characterized at all times by honesty, candor, and fairness. I think that those are very honorable attributes, and I see a lot of occasions when that does not happen, unfortunately. And then the second part, in fulfilling his or her primary duty to a client, a lawyer must be ever mindful of the profession's broader duty to the legal system. And then the order states, the Supreme Court and the Court of Criminal Appeals are committed to eliminating a practice in our state by a minority of lawyers of abusive tactics which have surfaced in many parts of our country. We believe such tactics are a disservice to our citizens, harmful to clients, and demeaning to our profession. So basically, these two courts, come 1989, had noticed some things developing in our profession where lawyers were starting to engage in abusive tactics, not be professional, start mudslinging. And it seems that that kind of thing has actually grown more in the past, say, 5-6 years. There have been several CLEs that I have noticed come out about civility. The national end of court, which I'm not trying to promote the end of court, but they're one of their fundamental principles is civility, and they actually have a new program where you can get a certificate in civility by taking a course of a few weeks. So it's really interesting to me that it took until 1989, but that it is also a recognition that lawyers had the evolution of lawyers' interaction, and I imagine this is mostly in litigation, but had evolved in a negative manner. And so the order then states the abusive tactics range from blank to blank and blank. Does anybody have an idea what they are, what the blanks are, or what they mean? So one of them you can kind of imagine because it's pretty basic. First one is lack of civility. Okay. The abusive tactics range from lack of civility to outright hostility and obstructionism. Such behavior does not serve justice, but tends to delay and often deny justice. The lawyers who use abusive tactics instead of being part of the solutions have become part of the problem. And as you see, this is directly quoted from the order that the two courts signed to enact the Texas Lawyers Creed. Kind of a sad truth in our industry, in our field, that this has evolved and become such an issue. And we're going to talk about a few specific examples a little bit later on. So the Texas Lawyers Creed itself includes 4 sections. Our legal system is the first one. Second one is lawyer to client. Third is lawyer to lawyer. And fourth is lawyer to judge. Anybody have a guess of which of those 4 sections is longer or has more issues than the others? I would have guessed lawyer to client initially because we have such very high duties owed to a client. But if you look at the order and see that it came about because of the evolution of how lawyers had started treating each other, then you would probably guess lawyer to lawyer and you would be correct. Lawyer to lawyers, that section includes 19 specific points. And you'll see this when I drop it in the chat box. Lawyer to client has 11 points, so it's somewhat long. Our legal system has 5 points because that's more of a generic and not necessarily person to person. Lawyer to judge has 9 points. So by far the longest is lawyer to lawyer, and the next is lawyer to client. So this is a discussion question. I'd like to get somebody to chime in or give some input. Why do you think lawyer to lawyer is the most detailed and the longest section in the Texas Lawyers Creed?
It's
Daniel?
it's an adversarial process, and some people take that a little too far.
Okay, very good. And one thing I noticed that in looking at this so much, and especially now, is that the order recognizes that that this kind of behavior denies justice. That means it's really imperative on the attorneys to behave properly, right? And lawyer to lawyer, because the lawyers can deceive and trick a court. And courts only have so much time and ability, and they're charged with following the law and so forth. And the judges take their own have their own obligations in regulations or rules. But that just struck me as something that lawyers really have the ultimate duties, because we are making representations to the court, and to some very real extent, the judges do have to take what we say to heart, at least without proof. When there's evidence, that's a different story. But there are loads and loads of misrepresentations made in court, in open court, some even on the record. I've experienced that a number of times with the opposing counsel, especially in these malpractice type cases. It just seems to be one that draws that kind of behavior for some reason, that practice area. Okay, next question. Which of the following subjects, this is tricky, do lawyers not need to advise his or her client? And it lists about 8 topics, because the Texas Lawyers Creed does set forth some topics that a lawyer must or is obligated to advise his or her client. So the subjects I've got listed here, I think there's 8, is civility, courtesy, proper and expected behavior, harassment of others in the case, delay tactics, frivolous pleadings, the lawyer's right to independently decide whether to accommodate opposing counsel, and mediation and ADR, alternative dispute resolution. Anybody have a guess of which one is not an area about which a lawyer must advise his or her client? No guesses? All right, somebody give me a guess. Put it in the chat if you don't want to say. Anybody want to do it? Take a wild guess? Maybe easy to eliminate some of them. Nope. All right. Well, let's go to the next slide. Okay, so this slide here, you see a number of obligations that we have to advise our clients that are in the Lawyer's Creed, points 1, 4, 5, 7, 8, 9, 10, and 11. So we have a lot of advising obligations that are set forth in the Texas Lawyers Creed. First, I will advise my client of the contents of this creed when undertaking representation. I'm willing to bet that maybe 7 times in history that it's happened since the Texas Lawyers Creed was enacted, at least as a matter of verbally making that kind of advisement. Number 4 is I will advise my client that civility and courtesy are expected and not a sign of weakness. That's because we are obligated as lawyers. Also, we are obligated to be civil and to be courteous. This section is from the lawyer to client. These points are from the lawyer to client section of the creed. The 5th point that's quoted here is I will advise my client of proper and expected behavior. So does that mean that we can, when a client wants to do something shady or something that is deceptive, can we follow that? No, we can't, because we have obligations, not just under the Texas Lawyers Creed, but under the Texas disciplinary rules of professional conduct. So the next one on the lawyer to client list, I will advise my client that we will not pursue conduct which is intended primarily to harass or drain the financial resources of the opposing party. I've seen many examples of this too, of lawyers doing things that are obviously intended to harass. I will advise my client that we will not pursue tactics which are intended primarily for delay. How about the client who tells the lawyer, I don't want to go to my deposition. I'm scared. It makes me nervous because I don't want to have to lie. Is the lawyer allowed to let that go forward and allowed to engage in tactics to delay the deposition because that's what the client has said? No. We have obligations as officers of the court and obligations and ethical mandates that we have to follow. Clients do not get to trump over things like that. All right, next one. I will advise my client that we will not pursue any course of action which is without merit. Next one, I will advise my client that I reserve the right to determine whether to grant accommodations to opposing counsel in all matters that do not adversely affect my client's lawful objectives. So opposing counsel asks you for a 2-week extension on discovery. You're still 7 months out from trial. Opposing counsel says, I've got a trial coming up next week, and I just have not been able to work on it. But your client wants to deny the extension. They're a real micromanaging type of client. That's not necessarily something that we can do because we have obligations, as we all know. The last point on lawyer to client that pertains to advising clients, I will advise my client regarding the availability of mediation, arbitration, and other alternative methods of resolving and settling disputes. So we have all these obligations that we owe to our clients that we need to make advisements that, our official title, if you look at your license, at least mine, it says attorney and counselor at law. Most people call, business card says attorney at law. I know of one firm that at one point they called themselves counselors at law. I thought that was very interesting. But it is a double title. And all these components of advising, in my view, they fall under the counseling section. The attorney section is representing somebody else, right? But counseling is advising. And these are all things that we are charged with advising our clients on. So which of these items here on the question are not in there? Anybody notice? All right, well, let's go to the second slide back. Frivolous pleadings. So while the Texas Lawyers Creed does not actually mention frivolous pleadings, the spirit of the creed suggests that a lawyer should not file them. These items don't mention frivolous pleadings. Nothing like I will advise my client that we will not file frivolous pleadings unless you count, which it kind of falls under the number 9, we will not pursue any course of action which is without merit. I suppose it could fall under there, and will advise my client of proper and expected behavior, things like that. But they don't actually, this section does not mention frivolous pleadings. But Texas Rule of Civil Procedure 13 does require that a lawyer have a good faith basis for pleadings. And what it says specifically is when you sign any pleading, you're making a representation to the court, and probably to an extent to the public, but it says the signatures of attorneys or parties constitute a certificate by them that they have read the pleading, motion, or other paper, that to the best of their knowledge, information, and belief, formed after reasonable inquiry, the instrument is not groundless and brought in bad faith, or groundless and brought for the purpose of harassment. Courts shall presume that pleadings, motions, and other papers are filed in good faith. I don't see this get enforced very often. Couldn't really tell you why, but this is the rule. This is our obligation under Rule 13. And I do think that filing frivolous pleadings would not be consistent with the spirit of the Texas Lawyers Creed. I doubt many people would argue with that position. What 2 rights does a client not have with respect to how a lawyer handles a case? The reason for this question is, as you can imagine, the Texas Lawyers Creed does actually specify a client does not have the right to do X or X. Anybody have a guess? I would guess, I've obviously written the program, so I have it in my head, but if I just read this question without knowing, I'd probably guess you can't tell a lawyer to lie. You can't make a lawyer lie like to the court. So let's see what the answer is. Lawyer to client section of the Texas Lawyers Creed says a client has no right to demand that I abuse anyone or indulge in any offensive conduct. That's pretty obvious. Once you look at it, right? Abuse anyone or be offensive. I have had occasions where lawyers have said that's what my client told me to do. Well, they don't have that right when you are acting abusively or in an offensive manner, such as making allegations that the attorney is lying. Like, I'll give you an example. writing a response to a motion to compel saying, motion to compel depositions, and the response, the other side's response, the lawyer writes, this proves that the movement never intended to take the deposition. And the client had told the lawyer to do that without any evidence or any grounds, just pure speculation. That's offensive to the lawyer. It's not founded on any evidence. It's just speculative anger and frustration and intended to give an advantage, an unfair advantage. So the second point, where a client has no right to give a lawyer of things a client has no right to give to a lawyer instructions that the client cannot give. A client has no right to instruct me to refuse reasonable requests made by other counsel. That's kind of like the extension example I gave earlier. Lawyer asks for a 2-week extension for discovery because he or she is about to go to trial. The client wants to deny it, but trial is 7 months out. There's no real reason to deny it. That client has no right to instruct you. And I think the second half of both of these, that's not stated, I think it's very implicit in both of these, is that if they do that, we don't have to follow it. Our loyalties to a client they're not unconditional. There are limitations, and these are 2 of them. Okay. So we're moving on to the section lawyer to lawyer. And this is a pretty broad question. I realize that there are all kinds of things that could be said about it, but this is meant for discussion and just to give you guys some input about what the creed says about handling of discovery. So the question is, question 4, how must a lawyer handle discovery? And so let me lead in a little bit. What do you think the creed says about objections, making objections to written discovery? Anybody have a thought? Nope. I'm probably thinking, well, I do, but I'm not going to say, or, just not interested in talking. But obviously there are, does anybody let me backtrack off that for a second. Has anybody had experience with lawyers making objections to written discovery that you thought were not appropriate? And I don't know if we have the raise your hand feature in this or not, but I don't see it in the toolbar thing. But I'm going to presume, I know Daniel has had that occasion. Daniel, have you had that happen?
I feel like probably every other day.
Yeah, so objections, lawyers, they have evolved in such a way that lawyers have taken objections and just make the most ludicrous objections on earth. I have had loads of cases where my interrogatory says, describe the facts supporting your breach of fiduciary duty claim, and specifically the allegation in paragraph 7 of the petition. The lawyer turns around and says that's not relevant. The objection is irrelevant. How in the world could it not be relevant, the facts that support the claim in the petition? That is absolutely absurd. There's just no way that is irrelevant. And another thing that has happened, and I know this for a fact, at least with some firms, and maybe more with smaller firms, I'm not sure because I wouldn't know, but the lawyers pass on the discovery to a paralegal, which is their prerogative, I suppose, but the lawyer's signing off on it. And that Rule 13 says a lawyer has to have a good faith basis. And there is a rule, I think it's 193, that says objections must have a good faith basis. So objecting went to an and I'm not meaning to pump me up, but it's just a real life example. When you ask for facts about a specific cause of action alleged in the petition, specific allegations in the petition, and the paralegal throws in a relevance objection, the lawyer needs to take that out. It's just obviously relevant. If the question asks something like, describe each and every fact, including the exact date and time and each person who was present and what the walls look like in the room where you were standing, then maybe there's objections to that. Because based on it being overly broad, and then it's irrelevant because they asked for who cares what color the walls were. I mean, that's an absurd example, but it's an absurd situation when people make these objections that are just so patently out of line and inappropriate. So the creed says, lawyer to lawyer, here are 3 specific points that the creed includes about only about discovery. I will refrain from excessive and abusive discovery. I want to stop there for a second. So one law firm I worked at, I think one of my coworkers had a case with I think it was with, and I'm being generic for purposely and because of lack of memory, because it was a long time ago, like 20 years ago. But my coworker had gotten requests for admissions, something like 1,000. And they said something like, admit you were not on the premises on January 1, 2007. Admit you were not on the premises January 2nd, 2007. And went on and on like that. Well, if there's ever been a scenario of excessive and abusive discovery, I think that something like that would constitute a prime example. And I've had cases where I've had requests for production in the hundreds. I had a hearing not terribly long ago that was on Zoom, and I won't say who or any details that could reveal anything, but it was something like 400 requests for production, and we were resisting them for various reasons. And my client and the other side's attorney, I actually don't remember a lot of detail, but when we went to court, the judge asked, well, which requests do you want me to go through? And the lawyer said all of them. And the judge says, you need to talk, go in the breakout room. The really crazy thing about that discussion was this lawyer actually um, dropped an F-bomb in the breakout room while it was just he and I, which was absolutely shocking to me. I'm pretty sure something in here in the Texas Lawyers Creed would speak against doing something like that. But that's just an example of how completely uncivil people can really be when it comes to discovery. And I see, Brenda, you made a comment a minute ago. There's a trend in plaintiff's bar to object to all the contention interrogatories and send excessive requests for admissions. I have definitely seen trends in some discovery on both sides, for that matter. And there is a really good presentation that the Texas Bar CLE had. I do not remember the guy's name, but it's on discovery objections, and it's probably 2 or 3 years old. And I can pull it up on my and see if I can find it on my screen. But it's a very good article about discovery and about discovery objections and how completely, utterly out of line they have become. Um, I'll find that and put it in the chat before we log off. So thank you for that comment. I don't know why admissions seem to, I guess people think admissions because they're deemed admitted, you can win, but there is some case law talking about what admissions are really intended to be and what they're not. So I would encourage everybody to look at what the case law actually says about them, because it's a little bit different than the rules suggest. Okay, so point 17 in the lawyer to lawyer section is a very long section, and it says, I will comply with all reasonable discovery requests. I will not resist discovery requests which are not objectionable. Boy, I'd love to blow this up on a 2x3 foot and put it in some lawyers' offices that I have cases with. I will not make objections nor give instructions to a witness for the purpose of delaying or obstructing the discovery process. I will encourage witnesses to respond to all deposition questions which are reasonably understandable. I will neither encourage nor permit any witness to quibble about words where their meaning is reasonably clear. I cannot say how many times I have seen these particular items be a problem, especially in the last 5 years or so. What do you mean by blue in the deposition? Sir, would you read that document? Do you see what it says on the very bottom paragraph? Which document? While the witness is holding the document in his hand. Abusive discovery, we talked about that. So the last point, lawyer to lawyer, the last point on discovery is 18. I will not seek court intervention to obtain discovery which is clearly improper and not discoverable. How about filing a motion to compel production of communications between a lawyer and the lawyer's client. I think that's compliant with this point. Pretty obvious that it's not correct. I do not at all understand how lawyers get away with doing this kind of thing on a continuous basis. It should not be and is not, at least on paper, how the law is written to work or how it's designed to work. But this is an obligation. All these are obligations that we owe and that lawyers owe to us. So, this CLE is not just about teaching us what our own obligations are. They're to teach us what our opposing counsel's obligations are. I don't know which judges abide by this creed or take it to heart. I have seen a judge somewhat recently have the Texas Lawyers Creed displayed right at the bench. But did I freeze? Can y'all hear me? My screen is frozen.
I can hear you.
We can hear
Okay.
you.
Okay, the little picture of me froze for a minute. So I have seen at least one judge have it displayed right at the bench, but I returned to that court and it was no longer displayed, which was interesting. But it is it is not just for us to know, but it is for you to know for your opponents. I'm not recommending that you use it in a specific way, but I do think because it's enacted by the Supreme Court of Texas and the Court of Criminal Appeals, if you do criminal work, it is relevant to raise or to bring up when you have particular issues with opposing counsel or perhaps with a client. If you have an issue where a client's trying to force you to do something offensive, then you can explain to the client, if you so choose, that this is what the Texas Lawyers Creed says. I've got a new chat message. Yes, can hear you. Okay. All right, great. Let me go to the next here. Okay. My screen is frozen again. Give me a second. Hopefully it'll catch up. There we go. All right. 17 is the longest paragraph in the entire Texas Lawyers Creed. The one that I just was reading about. I will not make objections. Let's see. It says I will comply with all reasonable discovery requests, not resist discovery requests which are not objectionable, not make objections or give instructions to delay or obstruct discovery, encourage witnesses to respond to depo questions that are reasonably understandable, and not encourage quick about words that are reasonably clear. What is it doing? My screen is again locked up.
Daniel, should she log out and try to log back in?
Yeah, we may want to try that. I like Zugi. I cannot hear any. Yeah, I think she did just log out.
I initially thought because I was on my phone, and so I was like, maybe it's just my cell phone, but um, I realized I went back to my computer and realized I was having the same issue. So,
Yeah, same here. Unfortunately, I'm on my laptop and I couldn't hear.
I appreciate y'all bearing with us on this. So sometimes it's the IP issues. I'm gonna go ahead and put the CLE number in the chat because we're at 45, so we're good on compliance. Everybody was here for what they needed to be. Okay, I just entered the CLE number in the chat.
You guys there?
Yeah, I can hear you.
Okay. Yeah, this is a nightmare. I'm sorry. Okay, so we lost a few minutes, so I'll just kind of barrel through this question. Uh, the creed we'll skip that question. The creed mentions obligations of punctuality and protection against unjust and improper criticism and attack. Anybody have a guess of who owes those obligations to whom? So turns out, and I'll just remind you, it'd be under lawyer to client, lawyer to lawyer, and lawyer and judge. Anybody have a guess which section that means? So it goes to lawyer and judge. Lawyers and judges owe each other respect, diligence, candor, punctuality, and protection against unjust and improper criticism and attack. It sounds kind of extreme that the courts felt the need to put in unjust and improper criticism and attack. Because, I mean, the way it reads is that lawyers may attack a judge and a judge may attack a lawyer. I think it means lawyer to lawyer as well, but also those. What level of attention must a lawyer to give to the issues in controversy? This is a pretty generic question, but you'll see where I'm coming from. This is in the lawyer and judge section. Because, when we show up to court, we have obligations to know what we're doing and to be familiar with the issues that are in controversy and not just walk in, oh, I got this case, 98 seconds ago. I don't know anything, but I'm here. So this item is number 8 in lawyer and judge in that section. I will give the issues in controversy deliberate, impartial, and studied analysis and consideration. This is lawyers should read, the motions that their opponents file, and the movant's attorney should read the responses, be ready to discuss them, things like that. I think we all know that we have obligations to be ready, but this is maybe a little bit higher than some people, some lawyers tend to abide by. Deliberate, impartial, and studied analysis and consideration, not a quick run through, not a 98-second review, but be prepared, know what you're talking about, know the issues in controversy. What obligations are owed as to facts and authorities, and who owes them to whom? You guys know, I don't know if, this is HYLA, so Houston Young Lawyers, and I don't know if our participants are brand new lawyers or what year you are, but I'm sure everybody remembers Shepherd being a big thing when you talked about legal research in your courses and in your any trial advocacy classes maybe that you had. Um, so facts and authorities, yes, we need to know our fact, not just the facts, but we need to know authorities and do our due diligence. So what are the obligations that Creed specifically mentions, lawyer and judge? And this is interesting that it's under lawyer and judge. I will not knowingly misrepresent, mischaracterize, misquote, or miscite facts or authorities to gain an advantage. Now, the reason I say it's interesting it comes to lawyer and judge is that we have an obligation with facts and authorities with opposing counsel too, and with our clients for that matter. But this one, they specifically, the two courts specifically determined that it was best to be under lawyer and judge, I suppose, because lawyers have to properly and accurately represent facts and authorities when before the court. Okay, next, lawyer to lawyer, final discussion question. I will not, without good cause, this is number 10, I will not, without good cause, attribute bad motives or unethical conduct to opposing counsel, nor bring the profession into disrepute by unfounded accusations of impropriety. I will avoid disparaging personal remarks or acrimony towards opposing counsel, parties, and witnesses. I will not be influenced by any ill feeling between clients. I will abstain from any allusion to personal peculiarities or idiosyncrasies of opposing counsel. And I've got a note there. This point recognizes the potential for conflict between opposing counsel. My question to you guys is, what are professional ways to handle difficult opposing counsel? They have some thoughts? Let me ask a specific question. When you write an email to opposing counsel and they've made accusations that you're doing something improper, how do you respond? Daniel, you had that happen before?
I'm a perfect angel over email.
So what do you do, Daniel, when you get an email from opposing counsel that he's accusing you of improper conduct or you're hiding documents, I know you are, or something like that? How do you respond?
Well, there's always two different kind of extremes. If it's somebody I've known for a long time, we see the same people over and over and over again. Um, I mean, on those, I want to talk to them face to face and like we'll actually talk about the issues and just, we've known each other for long enough that we can have a civilized conversation about it. Somebody who has been licensed less than a year and is just making up stuff, I will still attempt to, talking face to face is always better than, hiding behind email, especially aggressive emails, or just nasty phone calls. So, I mean, I think when, I'm correct and I'm just trying to explain how I'm correct. I mean, I always would prefer to have those kind of conversations face to face before we get down to the courthouse. If it's something I'm right about, and they're threatening to file a motion and do this and that, I'll tell them to just file it and let's go argue in front of the judge. Um, so I mean, and that's what the proper procedure is. So, when it's a silly argument or a misunderstanding, I mean, it's so much more efficient for everybody and less cost intensive, especially for your client, if you can just convince them not to file the motion and not to drag you down to court on something you're obviously going to win on. So yeah, I think that's kind of the split of just what kind of situation is it? If you're absolutely in the wrong, you should try and fix it before they file the motion because there's really no need to put your client through that.
Right. Well, thank you for that input. I want to go over a few specific examples with you guys to get your input and just talk about them. So point 9, I just put the Texas Lawyers Creed in the chat so that you guys can download a copy and have it for your reference. And you can print it out, and if you fold it up, it'll fold nice and nice up like a little brochure. Since the program that I was part of with the end of court happened, I basically leave this on my desk. I won't boast and act like I read it every day because I don't, but I've taken it more to heart and think about it more often than I had for a while. Not that I've been somebody just willy-nilly running wild, but I think it's a pretty important document for us to know. And so I want to ask a question. Daniel and I are both aware and have had experiences with an attorney, with two different attorneys, one attorney for me and a different attorney for Daniel, where the attorney, in my case, openly admitted in court that he records every single thing that happens in every part of his office. And we had depositions at his office. The co-defendants were taking his client's deposition and his witness's deposition. There's no notice in the conference room saying you're being recorded. There's nothing to give so that the lawyers sitting in that conference room have knowledge. I don't know about Daniel's specific scenario. I just know he's encountered another lawyer who records everything. What are your guys' thoughts on that? Does that fall within the lawyer to lawyer? And in my scenario, I do not have a case with this lawyer. It's long ago, but I wanted to know what do you guys think about whether that would be proper conduct from what you have heard about the Texas Lawyers Creed or what you've ever read?
I don't think it would be. I'm not in private practice anymore, and
Okay.
I was for a very short time. But I do remember the attorney I worked with for a few months advised me that every time I went to a mediation or a meeting with opposing counsel, and it was taking place at the other attorney's office, to be careful when I was left alone with the client to ensure that there wasn't any recordings being done. And so I thought that was interesting because I wouldn't have thought about that. So it made me very suspicious of every meeting I attended.
Yeah, that was good advice.
Yeah, just to be aware that there may be some type of recording devices in the room when I'm left alone with the client, thinking I have privacy and there may not be privacy. So, yeah.
Right. So thank you for that input very much, because that points out, another good benefit of attending the CLA and thinking about the creed is and things that happen. It'll make you more aware of things that people may do. And so now you guys know that there are lawyers, more than one out there who will do that. Whether it's proper or not, um, I don't think is really debatable, but let's just set that part of it aside. It's good to know that it has happened, because even if it is improper, it's going to still happen with some people. It just will, because that's part of the abusive tactics that made this document necessary in 1989. At least in the type of things I would contemplate anyway. That's obviously an assumption on my part. So, in closing, I want to leave you guys with what the very end of the order that enacts the Texas Lawyers Creed. It has this statement, which I thought was pretty meaningful. Let us now, as a profession, each rededicate ourselves to practice law so we can restore public confidence in our profession, faithfully serve our clients, and fulfill our responsibility to the legal system. I mean, we used to have a reputable, be a respected career path. These days, we're the butt of more jokes than probably any other profession, which is really sad, but a reality for us. So I hope that you guys have gotten something out of this. Please do download the PDF in the chat. You obviously, can do with it whatever you want, but and you don't have to download it, but I would encourage you to see it because it holds us to pretty high standards, but standards that we all should expect anyway, having taken those that we took when we got licensed. And again, before I close, I just want to say, as stated here on the last slide, special thanks and appreciation to the Garland R. Walker in a Court program on a Civility TV in April 2025. If anybody has questions for Daniel or I, here is our names and telephone numbers. You can find our email us. You can find our emails, or I think there may be a direct link on the website, thompsonco.com, thompsoncoe.com. We are happy to answer questions you guys may have, especially as it pertains to these subjects or professional liability, our firm, anything of the like. If you just need some kind of input about where should I go to learn more about some of these subjects or something that is on your mind, we're happy to do that. He and I both do some degree of volunteer work to educate the public on legal issues. So anyhow, I hope that makes sense. What I'm offering, just like basic, we want to help you guys know the area, basically, and we're happy to answer questions or talk about these types of cases. So I hope you've enjoyed the presentation. I'm not sure where the CLE number comes from. Daniel, do you have it?
Yeah, I put it in the chat. Let me re-enter it because
Okay.
that's when you were you just signed out. So let me put it
Okay.
in the chat.
Yeah, I can scroll up to it too.
Oh, can you scroll up to that even if you weren't in?
No, I just tried. Doesn't let me.
Okay, yeah, that's what I thought.
Yeah.
But yeah, in general, we want to thank y'all for joining us. This was our January CLE from the Houston Young Lawyers Foundation CLE program. We have several more throughout the rest of the bar year. If you have any interest, just let me know. We can get you the calendar invites, get you registered for them. There's other great Houston Young Lawyer Foundation events, variety of stuff. So check out the website for HYLF. Hopefully we see you at some of those events. And thank you again for joining us. And Kamy, thank you for presenting. This was fantastic CLE.
Thank
And
you.
it's a 1.0 ethics, which I desperately needed. So thank you for that also.
You're welcome. Yeah, sounds good. Well, thank you guys for attending.
Thank
Awesome.
you.
Yeah. Hope y'all have a great rest of the day, and hopefully we see you again at some more HYLF stuff.
Thank you.
Thank you.